I want to share some breaking news, Matt. How's that?
Nice. Look at that.
About a week ago, and we don't get many of these, we had a precedential patent decision come down from the Federal Circuit.
Remind me, what's the Federal Circuit and why is it important for patents and trademarks?
Oh my gosh. So in the federal land, which is where patents and trademarks exist, meaning we're not beholden to any state laws. We're free. We're nationwide. The court system is the district court. So there are districts, many districts, 2, 3, 4. Some states may only have one because they're small. And the district courts, they answer to one federal circuit. And then, of course, the only place to go from there is the Supreme Court. So it's this giant circuit. And there's these, 9 different districts. And so anyway, this whole different system, separate from Superior Court, right? State Supreme Court on the federal side. So with federal law, the Federal Circuit is just the one step before the Supreme Court. It's a really big deal.
They're ostensibly the experts, correct?
The experts, absolutely. I'm going to get to the facts here. Case is LKQ Corporation versus GM Global Technology Operations, LLC. It's a mouthful. You're not going to remember the name of it necessarily. Let's call it LKQ.
Is this a door handle case? Yes or no?
No.
Oh.
Sorry, man. This is about a design patent, though. Okay? Design patents. They are changing the precedent. So there's 400,000 design patents out there today that are not expired, meaning patent holders that own, enforceable design patents.
Probably saw one today walking around.
Perfect. Exactly. You saw someone, if you've been out in the public at all, even on TV, you probably saw an inventor who owns a design patent.
Yeah.
They're on shaky ground now. Just because you get a patent granted doesn't mean you're locked in. The law changes, and so now those may be subject to invalidation, the way this law shakes out. The circuit, the panel said, you know what? Obviousness, which is one of the core tenets of getting a patent, right? Has to be novel and non-obvious. Obviousness should no longer follow the age-old standard that we have been going by. And the Supreme Court in 1982 and 1996 affirmed what's called the Rosen-Durling test. That simply said, for a prior art or an infringing design, it has to be basically the same. That's the test. Basically the same visual impression as the patented design. For years and years, that's what won the day for Apple over the Samsung device, right? We talked about this before with a single button at the bottom.
Yep.
And the Egyptian goddess, all the same. But now they're saying, no, you know what? We should be looking at it the same as utility patents. And so they're now forcing the same standard under KSR, which is since 2007, than the traditional utility patent analysis, which is about the TSM, which is the same subject matter, it's the same teaching, suggestion, and motivation, right? Is there anything in the infringing or the prior art that would suggest or teach or motivate the same, what's trying to be patented, right? So it's a much broader, right? Much broader body, not basically the same. So they're saying, hey, in order for a design patent to get through, you have to meet this harder, more difficult standard under the KSR language. So that could invalidate a lot of these design patents, where now there could be a lot more prior art brought before the examiners. So, and it'll be tougher to get a design patent. So
interesting.
Not a lot of people like it, but that is an update here.
Yeah, no, I would think not. Typically, if you can't get a utility patent, then you would look to maybe get a design patent, right? In the alternative.
It'll likely still be much easier with the design patent. For those who aren't familiar, you're looking at trying to protect a three-dimensional object, okay? And so it controls based on the solid drawings. No words matter in the design patent, it's just the pictures and drawings. With the utility patent, obviously the written claims is what controls, gives you the rights.
So yeah, if we can't do the design patents, then we'll have to talk about maybe doing a trade dress application instead.
That's right. And we'll go right down the hall to Mr. Coltseth Chambers, where he'll help move something forward for you.